Hi everyone, welcome back to my channel. My name is Bhashinilaw. I am an attorney here in San Diego, California. I'm going to be talking about estate planning today, and we're going to be discussing a variety of different types of wills, going into what are wills, codicils, holographic wills. But before we get started, I want to start with some disclaimers. Estate planning is always state specific. So if you have real property, meaning a home or land in another state, you're going to need to discuss that with an attorney licensed to practice law in that state. What is said in this video may or may not impact that property that is outside of California. Also, this video is intended for informational purposes only. It does not constitute legal advice. And before you make any changes to your documents or take any action, please do speak with a qualified attorney in your area so that you can get advice specific to your situation. That being said, let's dive in. So today's video is all about wills. And in California, there are different types of wills that you can create. There's something called the statutory will, which is basically a form that California legislature put together that you can fill out and indicate what your wishes are for your estate after you pass away. So who should get your things after you pass away? You could name specific individuals, you could decide how much each person gets. There's a lot that you can do with that document. Also, with wills, you could write your own will. You could hire an attorney to write a will for you. There are a lot of different options. But some of the terms that you're going to hear when you start discussing wills is you may come across something called a codicil or a holographic will, and you might wonder, what is that? Is that some kind of 3D technology? No, just kidding. No one thinks that. So let's look at what these things are. So in general, let's start with how to execute a will in California. Here, to execute a valid will, first of all, you need to have a person who's signing the will. That person is generally referred to as the testator. And the testator needs to have testamentary intent, meaning the person has the intent for this to take effect after they pass away. They need to be of sound mind. So a lot of times when people are thinking of wills, they might be in a hospital situation or end of life situation. And there is the possibility that they might not be of sound mind. They might have, they might be under medications that is impacting their ability to process information. They might be in a coma situation. They might be in a variety of different stages of disorders that may prevent them from properly understanding what's going on. So in order to execute a will, you need to have capacity. And by capacity, we mean be of sound mind. You need to understand what's in the document, what you're executing. And without that, you cannot sign a will. Also, you need to be over the age of 18, you need, which is generally not an issue, and you need to do it voluntarily. It cannot be a situation of undue influence or duress where somebody might be pressuring the person to sign this document. If that's the case, most likely the will be contested and it will drag into court, and who knows what will happen once it gets there. So those are just some very broad overview of what the circumstances need to be. With wills, when you're executing them, there are specific California law that applies. that says that the testator need to sign it. If they are not able to sign, but they are of sound mind and do understand what's in the document, have that testamentary capacity for the document to take effect after they pass away, and for whatever reason, let's say they cannot sign it themselves, they can instruct somebody else to sign it for them. Generally, this is done in their presence and in the presence of witnesses. But that's one of the ways that a will can be executed in California. Now, I mentioned witnesses. Under California law, you need to have two witnesses. The two witnesses need to see the testator sign the document. So let's talk about witnesses. When we say witnesses, we mean two people who are present for the signing, who are over the age of 18, who are of sound mind themselves. So they also understand what's going on and what this document is, and that the testator intend this document to be their last will and testament. And they generally should not be someone who's listed in the will. So if in the will someone's listed as a beneficiary, for example, they should not be a witness. And the reason is that there's a presumption that's created if they're listed in the document and signs as a witness that they may have caused the testator to sign this, that there could have been an undue influence situation or duress. And then again, you're looking at a litigation situation. So generally speaking, it should be two uninterested parties who are present and signing as witnesses. So that's just a brief overview of what a will is. So let's get to what these other two documents are. So two of the terms that you may hear when you're talking about wills is codicils and holographic wills. Let's start off with what a codicil is. Codicil is basically a second document that amends an existing will. So when you have an existing will, and let's say you want to make a change, let's say somewhere in your will you state that you're giving everything to your children and you name two of the children, but you want to add a third child. You may do this through a codicil, creating a second document that references the first document where you are making a change. So it's not on the same document, it's on a second document. Keep that in mind. It also needs to be executed in the same way a will would be executed. So the same rules that apply to a codicil, meaning the testator needs to sign it in the presence of two witnesses, and the two witnesses need to sign it in the presence of the testator. So it follows that same rules. Also, in general, whenever you're dealing with any kind of estate planning document and you're signing something, always, always, always put a date on it. The reason is that often these documents can be litigated, and if they are litigated, they're drawn into a court situation, and people are trying to figure out what was executed when. That date becomes so critical. And also when you're talking about capacity of the testator, that date becomes critical, because if somebody was too far gone to sign a document, but this codicil shows up that changed the terms of an existing document, we of course want to know that the testator was of sound mind, had that understanding of what they were doing. So it is always critical to include that date. And And in the world of estate planning, anything that's done later in time, the last document generally is the one that's gonna um, be used. So the last document controls. Just for that reason, those dates become really, really important. So always, always, always try to include a date. So let's talk about what a holographic will is. A holographic will is one that is handwritten. That is the key aspect to a holographic will. So instead of a typed out will, it's one that's handwritten. The will needs to be in the handwriting of the testator. That is that is critical. It should not be somebody else writing it and then the testator signing it. It needs to be in the handwriting of the testator. The testator needs to have that testamentary intent, need to be of sound mind, just like you would with any other will. And the testator need to sign this document. Unlike a regular will, this does not necessarily need to have a witness in order to be valid. That being said, if there are uninterested witnesses that can sign on to this document, they should, because that will help in validating this document if it's ever raised as a question as to the authenticity of this document. If somebody's trying to attack the document and they're saying the testator did not have the capacity to execute this document at the time that they executed it, or someone was influencing them to execute this document, something of that nature, having witnesses help to make sure that the document is upheld. Also, going back to dates, include a date when you sign a holographic will. So now that you know what wills are and what a codicil is and how holographic wills work, let's talk about how to change a will. So life happens, and once you create a document, life can take different twists and turns down the line, and you may want to make a change to your will. When that happens, the best practice is, one, speak to an attorney, because they will help you to figure out how to do it in the correct manner that will uphold the document and mitigate the chances of litigation. But beyond that, there's two things that you can do. You can execute a new will, which means, remember what I stated earlier, that in the world of estate planning, the document that was last created is the one that controls most of the time, assuming that it's not invalidated for some other reason. So you could always revoke a document you have already created and replace it with a new document. That is one option. The other option is to make changes to an existing will. And the way that you would go about doing that is using a codicil, which is creating a secondary document that is attached to the primary document. There are some problems with doing a codicil. Maybe that codicil will be lost. There might be a question as to the validity of that codicil. So in general, the best practice would be to restate the entire will, so create a new will. But the other thing that I want people to understand is that you should not just cross out things on your existing document and write in new things. I know there are people who do that and they will initial next to it. That initialing helps. However, at the same time, that is not how you go about changing these documents. If you want to change a document, use a codicil or execute a new document, um, and follow the rules as to proper execution, because that's going to be critical to avoiding litigation. So understand that if you were to amend a document by simply crossing something out and inserting any new language into that document, um, now it's in the hands of the court whether that those changes will be adhered to. A court can decide to disregard what you have attempted to do. There might be reasons to doubt the validity of why it was done, who done it, when it was done, all those things. So it's always best practice to execute a new document or to execute a codicil so that you are making changes in a way that is in compliance with California regulations. You want to make sure that you are following the rules as to having testators sign and having the witnesses present for that signing and signing in the presence of the testator. So I hope that this answers some of the questions that may arise when you hear these terms. And if you have any questions or comments, please do insert a comment to this video. And please note, do not put any personal information on any comment for everyone's sake. For your privacy, it is not a good idea to include private information on a public comment. So please avoid doing that. Please like this video, subscribe to the channel. I'm going to be putting out other content related to estate planning and business law in the weeks ahead. So thank you so much for joining today. And as I stated at the beginning of the video, this was for informational purposes only. It does not constitute legal advice. If you would like to speak with me or another attorney, please do that. So now that you know what are wills, what are codicils, what are holographic wills, and the best practice for making changes to an existing document, I invite you to make comments on this video. If there's questions that you would like for me to answer in a future video, please insert it in a comment. I remind everyone that comments are public, so please don't include any private information. But if you want to put a scenario that you would like for me to address, please do so. I am going to be putting out more content related to estate planning and business law, so stay tuned, and I hope you will join me again at a future date. And as I stated at the beginning of the video, this video was intended for informational purposes only. It does not constitute legal advice. If you do have a question specific to your situation and would like to speak with an attorney, I encourage you to contact somebody in your area. Feel free to contact my office if I can be of any assistance, but speak to an attorney before you take any action. With that said, enjoy the rest of your day. Thank you so much for joining. And like and subscribe to this channel.